Okay. Okay, and this is navigating content, AI, generative AI content and copyright challenges. And today we are fortunate, and I stress fortunate, to have George Likourezos, a partner with Carter DeLuca in the patent and intellectual property group, and John Sepulveda, who's an associate of George's. John, in addition to being an attorney, has a wide breadth of experience with technology and technology products, and he also has a degree in electrical engineering. So, as most of you will, I'm sure, have guessed, law is trying to catch up to technology. This is the man who really can stay in front of it. So without further ado, as I said, if you've got questions, please put them into the chat. John, I'm going to make you the host, and I'm going to introduce and let George take it away and tell you a little bit about Carter DeLuca.
Sure. Thanks, Ellen. Hi, everyone. Thank you for inviting us to speak today. So with Carter, Deluca and Ferrell, we're an intellectual property law firm. So this is our specialty: copyrights, patents, trademarks. So we bring to our clients anywhere from startups to multinationals value because we protect their intellectual property. And like Ellen said, the law has to keep up to as technology changes. And we seen generative AI in the last year or two come to bear, and we're all using it. And whether it's marketing, whether it's for creating websites. And then the question is, who owns the content? What happens to traditional being an author, human being the author, owning that content? So the law is trying to keep up, and we want to answer these questions. And John's one of our in-house experts on copyright law, and I'll turn it to John to give you his presentation, provide best practices. And of course, we're here after the webinar for anyone to reach out. And if you have any particular questions that we cannot get to today, we'd be happy to talk to you afterwards. So take it away, John.
Great. I'll share the presentation at this time. So you guys see the presentation? Right. Yeah. So, so today we're going to, I guess, initially discuss, understanding AI-generated content, to go over the questions of what is AI-generated content, some common tools that are used and platforms, and the benefits of using AI for content creation, which I think some of these benefits are going to be super obvious. We'll also discuss copyright issues in AI-generated content. We'll discuss the law and its applications to AI, the legal framework. We'll discuss ownership and authorship, as well as ethical concerns. And then finally, we'll discuss protecting your AI-generated content, various strategies for copyright protection, registration of AI-generated works, which is somewhat of a hurdle, Creative Commons and other licenses, as well as monitoring and enforcement. So understanding AI-generated content. So generative art, it's art that's created using AI algorithms and various computational processes. Generally, AI algorithms, generative AI algorithms, they're trained using either images or music or whatnot that has been tagged to indicate what those things represent. User will typically input a text prompt, and the algorithm will create new images based on the relevant tagged images in its training set. Okay, examples of this are DALL-E 2, Midjourney, ChatGPT. Some other examples maybe for generating music would be like Udio or Suno, right? So, and the software generates, I have to say, what they're able to do just based off your prompts is really pretty amazing looking, amazing sounding, and very useful works. I've been seeing a lot of AI content used in marketing lately. Often people, ad copy, It provides an efficiency and speed in generating this AI content. There's a cost effectiveness because of that speed. And a lot of times it could be used to enhance creativity. It could be used to supplement something an artist is already doing on their own. That maybe, to help generate a background for something or to enhance certain features of the drawing or the image or of music, or sometimes just to jumpstart ideas. So copyright issues and AI generated content. So as I mentioned before, generative AI, it's been used to create things, music, images, literary works, videos, and under US copyright law, most works of art like these are typically eligible to receive copyright protection. Under two conditions though, okay? Copyright protection subsists in original works of authorship fixed in a tangible medium of expression, right? So what does that mean? As simply put, if I were to author a book, when I put that pen to paper, so to speak, and write my original work, as a human, I author my work, it's in a tangible medium, maybe I type it instead of writing it, I technically have a copyright at that point. Now, it's not a registered copyright, but you do have a copyright. So, as I mentioned, only human-authored works may register a copyright within the U.S. Copyright Office. There was a case, Naruto versus Slater. It's the monkey I have on the slide there, where basically Slater was a photographer. He set up a camera. The monkey took its own picture in the wild using the camera. And PETA had litigated for the monkey to try and get the monkey authorship rights. So anyway, long story short, the court had held that no, a human has to author the work. It can't be an animal, it can't be a machine. Basically, the issue you have with AI-generated works is that the computer-generated art, it may lack expression or creativity or originality. But if it's completely computer-generated, the Copyright Office currently holds that if you're merely just typing in a prompt, you don't have human authorship. Okay, so what is authorship? It's the author is a creator of the original expression, excluding things like work for hire. And it's limited to humans. Originality is correlated with independent creation, and there has to be a minimum of creativity, and it's a pretty low bar. But you can't copyright facts, right? But it's the expression of your idea that you're actually protecting. So in Feist, there was a case where there was they had an arrangement of things in the white pages of a telephone book. And the court had held that the white pages telephone directory wasn't copyrightable because it lacked originality and creativity because they merely just put everybody in alphabetical order. So US copyright law. So you have to look to the Copyright Office has a compendium, which is great. It helps provide guidance for a lot of these issues that come up. But copyright law itself subsists in Title 17 of the US Code, the Copyright Act. And there's several international agreements. The Copyright Act, the copyright law in the US has been updated several times. There's the Berne Convention, the Universal Copyright Convention, TRIPS, WIPO. So case studies and precedent here. So partially AI-generated works can be protected. And basically the US Copyright Office says that you have to disclose your use of AI. There was an artist, Kashtanova, she generated graphic novel using Midjourney to generate the figures that she used in, I think it was a graphic novel. But she did a lot of arrangement and editing. So it wasn't completely AI generated, but AI generated images were used during the creation of this novel. There was some back and forth. The Copyright Office initially didn't want to grant a copyright to this work. And I think part of it was based on, she had a blog where the blog discussed the use of AI to generate the works. I guess then after the back and forth, the Copyright Office said, okay, well, you can have a copyright in this, but you're only protecting certain features, maybe your arrangement or how you're telling the story, and not necessarily the underlying images you generated from using generative AI. And I think in a lot of the analysis that the courts use or the Copyright Office uses, they often will refer to either the Naruto case I discussed before, or there was Burrough-Giles. So the Burrough-Giles case was a case where back in 1884, where there was an argument that, hey, look, the camera, a photograph is not copyright protectable. And the argument was that the machine was doing all the work. So the court, though, held that the photograph was a writing within the meaning of the Constitution, so that you're entitled to copyright protection. And a lot of that had to do with how the photographer arranged what was going on in the picture. So you didn't, like, if you took a picture of Oscar Wilde, like here in the slide, you wouldn't have a copyright on Oscar Wilde. You'd have the copyright protecting your arrangement and things you did within the picture. But yeah. So authorship. So we have this authorship, this ownership, and so authorship is the creation of the original expression in a work. For works made for hire, the commissioning party is the author. For a corporation, an employee doing the artwork in the normal course of business using the business tools, the corporation is the author. Ownership, well, typically the author is the owner, unless the rights have been assigned to another entity, or in like the case of the corporation with the employee doing the work in the normal course of business. The author, the owner and the author there in both cases are the corporation. Okay, determining authorship of AI-generated works. So you can think of, there's many different ways to use AI or generative AI when you're creating work. I think, one example might be, Microsoft Word. As you're editing and, making up a document, maybe you're writing a book, Word may suggest the next words to use, or may suggest a correction to your word, right? Some of what Microsoft is using in the background is AI. So the question is that an AI-generated work? No, we wouldn't really think of that as such, because the original idea is coming from you, the author. Okay. The tools in Word are really more like think of it as like referring to something like a thesaurus or a dictionary, right? Now you have the other end of things, which is like solely AI-generated works. So if I go on Udio and I say, please create a song in the vein of Twisted Sister, but maybe make it country, whatever. The output of that is probably, or definitely, in terms of the Copyright Office, not going to be registerable. They're going to say that the mere prompts weren't enough. The Copyright Office issued a guidance in, I think it was March 16th of last year, where they gave some examples, and purely prompt generated artworks, or I say art works, is not registerable. And so this leaves the legal question currently of what point does authorship transfer from the human to the machine? Well, currently there's no bright line test. What I can say is that the more that the author did, and the more the author's input into the beginning of the process, the more likely the thing is registerable. So an example might be if I drew some stick figures and then passed that into a generative AI tool that then fleshed it out into two people sword fighting with beautiful mountains in the background and whatnot, that is likely going to be able to be protected, registered by the Copyright Office. However, if I merely typed a prompt saying two people sword fighting with beautiful mountains in the background and it generated the exact same thing, that definitely wouldn't be registerable. Okay, and under current law, solely AI-generated content, it's in the public domain. What does that mean? If you generate a script for a movie, a drawing, a painting, and something for an advertisement, a song, there's no copyright on that.
John, quick question.
Sure.
On this. if I use AI to generate, say, a blog or a white paper, and most of it was generated by the AI, by the machine, obviously that would not be copyrightable for me, correct?
Right.
Okay. Does that mean that anyone can take my idea and run with it?
Somebody would be able to directly copy exactly what you did if you, well, okay. So typically, yes, in terms of copyright infringement.
Okay.
Now, most of these AI generative tools have some sort of license agreement, I guess, on who and how, what owns. But that is not, copyright infringement. There may be a contractual issue of some sort. Maybe if you're also a user of the same generative artwork, website, you may be breaking a term, and but that's a contractual issue. That's different than in terms of copyright. There's definitely no infringement there.
And the reason
Now
the reason I raised
Okay,
that, Steve actually asked if Photoshop uses Adobe Firefly, which according to Adobe, it uses features of Firefly. So he could be in a position where if the majority of work that he turns over was generated by Firefly, he would not be able to copyright it. Correct?
And I don't know that feature of it's Photoshop well enough. Generally speaking, if I was in I had used Photoshop a lot, but it was all any pre-AI features. And so an example might be if I was in Photoshop and I drew some shapes and did like a gradient fill or something like that. Although the computer just did a lot of work on that fill, I could still get a copyright and register a copyright in the artwork I did, even though Adobe did a gradient fill and that in that area. I'd have to take a look at the specific feature of Adobe to really be able to comment accurately. But if it's starting from a text prompt and it didn't start, maybe if the author sketched something first and then applied some sort of Adobe tools, you probably have something registerable. If they text prompted first, probably not. Again, there's not a bright line test.
Can I give you my example?
Sure.
I did a photo of a bottle, a spray bottle with a black background, and I used my hand, and then the client changed their mind and wanted a female hand. So I selected my hand and said, create female hand. And I told it what color to make the nails and everything. And it did it. It wasn't perfect, but it worked. So how about that?
So just as a quick question, you took the photo in the first place as well?
Yeah, correct.
Yeah. I would argue this would totally be registerable.
That's what I thought.
So when you go to register something like that, the Copyright Office, I said a little bit in passing before, but you basically have to disclaim on the copyright registration form that some AI was used, AI was used to generate some portions, or may have assisted in some portions of the artwork. They don't seem to care at the moment the specifics. You don't have to say, hey, I generated this hand using this program in this way, just that you used something. I think their position seems to be that if litigation happens later on, whatever it is comes out in litigation later on. Next slide. So in terms of moral rights and attribution, that's something I did want to mention. So it is kind of Steve's question triggered this in my head. There's really three issues that go on with copyright and generative AI. There's input related questions, right? So the training data, all of these generative AI software, they're possible because they trained on a large amount of data. Typically that's, word publicly available is probably not accurate, but that accessible through the internet. And what happens is some of this data, or much of this data, is protected under copyright. So there's a number of lawsuits right now happening because, my slide right here, Getty Images is suing Stability AI because Stability AI used Getty Images data as a training data without a license. And then using Stability AI, you were able to generate images that may have inadvertently had a Getty Images watermark on them. And it was clear what Getty image the stuff came from. So, and they're not the only ones suing. I think Udio and Suno, which are both generative AI music programs, were just sued by the recording industry for $150,000 per work. Okay. And they've probably used thousands and thousands and thousands of works in their training data. So that's the input issue. Then the output issues there too. One is the work I created with this registerable, and separately, if the work I created is substantially similar to a work that has a copyright on it, am I infringing somebody's copyright? And yes, you may be, because that law hasn't, that set of law that really hasn't changed, whether you're, in terms of the infringement, right? Now, some generative AI companies, in their terms of service, have an indemnity clause. You may want to look at the terms of service to see if they do indemnify their users from getting sued for the works that their software generated that you're using. Because you may generate something with one of these programs, and based on the training data that they probably shouldn't have had in the first place, may create something that's infringing someone else's work, and then you end up getting sued when you use that in an advertisement or create a song using it or whatever. So back to the slide. Basically, you can consider these like derivative works that were created with the AI. So the copyright owner might be able to show that the output infringes their copyright if the AI program had access to the work and created a substantially similar output. So then that substantially similar is the normal copyright infringement test. Additionally, some countries will have moral rights, so the proper attribution has to be made. So if you did use something that came from some sources, you may have to attribute, what your starting point was from. So that's just something to keep in mind as well. So now protecting your AI generated content. Like I said, it's important with anytime you create a work, artwork, songs, photographs, etc. It's important to register with them with the Copyright Office. Registration is very inexpensive. It's, relatively hard to mess up. And I definitely recommend doing it because quite often, you don't think about this till it's too late and someone's already infringing you or whatever. So registration of copyright allows a couple of things. Allows you to go to federal court against somebody who's potentially infringing you. Initially people will typically, if a client comes to us and say, hey, look, I have this this copyright on this book. I see somebody's infringing it or potentially infringing it. I'd like to send them a cease and desist. We'll prepare a cease and desist letter. And it carries much more weight when you have a registered copyright than when you don't. The other benefit the registration of the copyright brings is that you can then sue for the damages are just much higher damages. Additionally, you have a registered copyright. I think it's a little bit easier to license to somebody your work. They may be a little less likely to try and rip you off. Additionally, you may want to consider, you have some works, maybe you're showing them off on your Instagram feed or something. To police online platforms, take a look, see if anybody else is potentially infringing your work. Like the example we had before from Ellen of the white paper, right? So maybe you didn't AI generate it, maybe you actually wrote up from scratch your white paper, but if somebody else is using it, or replicating it on their website, you can do a DMCA takedown request. So there's other ways other than the cease and desist. You can try and get these things removed. Often with artwork, there's rampant photographs is probably the worst. Rampant online infringement. People take photographs online, from somebody's feed or website willy-nilly online all the time, and we'll often get I guess clients will call us up, say, "Hey, listen, I just got this, you know, an email or letter from somebody saying they own the original license. I saw this thing online. I thought I could just use it." Well, not necessarily. You have to. Anytime you want to use any image, you need to know who, you know, whose image, who the rights holder is, and get proper, you know, permission from them to use it, be it through either, you know, a paid license or free or whatever. So in the Copyright Office, you know, for these things, you fill out the standard application. Any AI content that is more than de minimis. Okay, so what do I mean here? What is de minimis? So basically, if you have more than, just say with Steve's example before, pretend it wasn't the whole hand you removed. Pretend it was you fixed up a thumb. That's probably de minimis. Yeah, it's a little bit of a feeling to it. But basically, if, you know, replacing the whole hand, I would probably note that. And basically what it means by excluded from the application is it means you're basically putting a note in the application that a portion of this should be disclaimed because it was generated using AI, but you don't have to specifically call out what portion that was. Additionally, like I said, the you know, it should be noted in the author field if it's I actually probably should say more than de minimis. And remember, AI can't be the author itself. So what does that mean? You know, if Steve is authoring something, he can't put Steve and ChatGPT. It's just Steve. Okay, it will get rejected from the Copyright Office if you put the name of an AI in the author field. Okay, in terms of licenses, look, Creative Commons licenses can be used to grant blanket permissions for reuse of a work. However, lack of a Creative Commons license doesn't prevent the usage of a work for AI training. So a lot of the legal argument right now, this is that like that input question I talked about before, where they're litigating that whether the training data is you know, infringement or not. A lot of the defense that these companies are using, they're saying it's fair use, right? So right now, the New York Times is suing, I think it was OpenAI, and OpenAI's defense was, look, when we're using ChatGPT to generate information that really looks like your articles, this falls under fair use. We're really just regurgitating back facts. And that's a lot of the types of arguments that the generative AI companies are using to defend themselves in these sorts of lawsuits right now. I think it's going to take a little while to see how all of that shakes out, but it's right now a hotly litigated area. You know, in terms of contractual protections, you really want to draft very clear terms of service and user agreements regarding use of AI-generated works. You want to ensure proper licensing. And remember, as I said before, if I were to generate an image of something, you know, using generative AI, and then maybe incorporate that into as a small part of a much larger thing. Let's go back to that hand example before. So Steve makes his artwork. There's that hand. I now copy that hand and use it in my own artwork. He won't be able to go after me for the hand, right? So just some things to think about. So tools for detecting infringement. Okay, so some of the things you may want to think about if you do artwork and you're afraid of the you know, people's use of generative AI may infringe. Maybe your stuff was possibly used for training data. You know, look for watermarking. I gave the example before of the Getty image watermarking showing up, you know, when the images were generated. Google reverse image searches you can do to see if something looks, you know, strikingly similar, or technically substantially similar. But the you know, you could search yourself, you know, manually, and then you could always do, when you find stuff, DMCA takedown requests. And you know, ultimately, what do you do when you think one of your copyrights are being infringed? Consult an IP lawyer. That will help you understand your rights. We could file a cease and desist or do a takedown request. and help you set up for litigation or whatnot. And that's pretty much it. I guess now we can take questions. Yeah. Yep.
We don't have any more questions in the chat, so I'm going to open it up to the floor and ask, does anyone have any questions? I'm gonna reclaim the host so that we can stop this share. There we go. Now we can actually see people. And Jennifer?
So I know you talked a little bit, John, about how they can use your content for to train their models. If it's out there on the web, it's kind of in the public domain. I get that. Are there any concerns, like if you're using ChatGPT and you're like, oh, I'd like to put my, blog or article or whatever in there and get some suggestions on how it could be summarized or create a social media post or whatever, something like that. It's content I own. Once it goes in, or let's put it this way, I wrote it, so I'm not submitting every blog to get a copyright. That's not realistic for me. And I know I know. But once it goes into one of those programs, or once they use it, do they own that content then? Because I inputted it in there.
So for whatever service you use, say it's ChatGPT, look at their terms of service. They'll usually expressly say in their terms of service. So I don't know if you saw the recent thing that just came up with Adobe, where Adobe changed its license agreement to allow them to train off, and then they're like, oh no, but we're not going to train generative AI unless you put the artwork in a certain spot, but we'll still look at your artwork electronically, so. Ultimately, it's always up to the terms of service. One of the things I would be cautious of is using anything that does have an AI component. The likelihood of a company wanting to use your data as training data is very high. However, you said you have a blog. It's likely a blog is being crawled anyway online by one of these services to train anyway. Okay. And you'd have to, like I said, you'd have to, in terms of ownership, you'd have to look at the terms of use of ChatGPT. You probably still own the underlying work. However, they may be able to make some arguments in terms of how they fixed your words up, or the summary they generated, or.
Sure. No, and that makes sense, and that's kind of what I assumed. I know you have to do a lot of reading. I've heard some people use it for for editing, and that's fine. I actually feel like I do better editing than AI, but probably a lot of us on this call feel that way. The other question I had, if I may, if I'm not overstepping, is some people have been using it from a business development standpoint. So taking a proposal and then, how many times do clients not redline it? Either doing a comparison, which I feel like Word does anyway, but anyway, either doing a comparison or saying change X, Y, and Z and put in some different things and having AI do it faster than maybe, a find and replace type thing. Okay. Is there a chance that again could be used to train somebody else who might be like, hey, write me a proposal for, I don't know, business consulting services, that may spit out your exact proposal?
I think with specifically ChatGPT, and I have to look again because the terms of service changed. So it was at one point where if you had their paid model, that they didn't use your data for training. And then if you had their free model, your data did get used for training. I don't know how it's currently stated in their terms of service, so you'd have to look. So there was a case a few months back where some engineers had they think they were at Lockheed Martin or Boeing, one of those companies, and they had put in some specifications in to type up to generate something for them. And it ended up being used as part of the training model, and they got in trouble. So I think I would always hedge to assume that something is going to use you for training, and
this is totally non-legal, but one of the things that I've found is that some tools that you use, like Grammarly, which helps you
Yeah.
to come up with better wording, the terms of service, they're clear that they're not doing anything with your content. They're not storing it. ChatGPT's free version, as John said the last time I checked it, it was kind of like, hey, you put it in, we gave you this tool for free, we could do whatever we want with it. And the paid version terms of service were quite different. So I haven't looked at it recently, but you know, the thing that I've found is if the tool is intended to edit or facilitate what you're doing, it seems that it's less likely to use your content or store your content. And one other thing, just from a technology standpoint, the servers that it takes to provide artificial intelligence are super, super expensive. So unless there is a financial gain in keeping your content or using it for some reason, probably not going to be in trouble. However, our standard practice, which is when the terms of service comes up, just click yes, I agree, and move on. It really needs to change now.
Yeah. Ellen, I think you're spot on. What's the saying that when the product is free, you're the product?
That's correct. Absolutely.
So yeah.
Other questions? Pam?
Hi. So you said something before. So if I learn that my content has been used for training, right? Training the AI. And even if I go back and say, no, you can, it's copyrighted, whatever. Sort of once it's out there, right? The horse is out of the barn. It's going to go. There's no way to like crawl back my content. Is that correct?
Yeah. So
or roll back or pull it back in.
So short of them having to retrain the whole model, no, you're correct.
Exactly.
But
yeah.
So what are the possible outcomes? Say you do have a case and you are able to prove that they infringed you, and the court does feel it was infringement, them using you as part of the training. Maybe the damages is that you get some sort of license where every time a work is created, you get a licensing fee or something like that. So there's other things that can end up happening.
But then if
it's unlikely, like I said.
But then if it like changes just a little bit every time it's used, at some point it's going to be unrecognizable, right? As yours, unrecognizable.
That's true. So I think the argument that the AI companies make is that, look, you as a person, you go to the Met, the museum, and you look at a number of different paintings, and now maybe you are into painting and you had some training and you start to paint, and maybe you take a little bit of Picasso, a little bit of Van Gogh, in making your own thing. At what point are you ripping somebody off or not, right?
Well, and
copyright doesn't protect style.
Yeah, I had that thought. Like I thought Mona Lisa, right? Like we all know what that is, and we all know who painted it. But at some point, if it's continuously distorted, when is it no longer the Mona Lisa?
Substantial similarity. Yeah. So basically, the test is substantial similarity, and like, I guess the ordinary person looking at this, would they think it's substantially similar? Okay. So there's that.
It's in the eye of the beholder, right?
Well, so if, a little bit, but actually, it's probably in the eye of the expert that they use at the court. But ultimately, if you trying to think how to phrase this. If it's so different, is it the same thing? Is somebody ripping you off if it's so different?
Yeah.
So
this is fascinating conversation.
For me as well.
Yeah.
We have
So
question.
I think there was oh, go ahead.
Yeah, I was just going to say there's another question in the chat. JC asked, do you have any advice or guidance for organizations that want to write internal policies on using AI tools?
Well, at a very high level, yes, schedule a call with an attorney to help you draft this. But generally, I think especially nowadays. So there was, I'll go with the case first. I think we might have heard this on the news. There was a few lawyers that use ChatGPT to do research, but it doesn't do research. And they cited some cases, and the judge is like, these aren't real cases. And the senior lawyer didn't actually review it. A junior lawyer had generated it, who was working for him. And so, that's really kind of a workplace issue. If you think about it, you should have some policies in place, at least providing guidance on, if you do use it, maybe you should provide an indication to the other people you're working with so that they know to check things, right? Because especially the large language models are very susceptible to what people have been calling hallucinations. It's errors, it's mistakes, So how does a large language model work? They're effectively predicting the next thing that would be said in a conversation. They don't know facts. They don't know, there's no checking of facts. They're just predicting. So they can make up and say wrong things till the cows come home. I do a fair amount of computer coding on the side. And if you ask ChatGPT to generate you a macro for Word to do this, that, or the other thing, if it's something that people have done before and it's seen the info, it was trained on info on GitHub, and it's able to, spit you back something very accurate, very good. If you ask it to do something people haven't done, you have a really weird use case, it has such a tough time. It'll give you garbage info affirmatively. It looks like it knows what it's talking about, but it's absolutely wrong. Like it was with the cases that were cited for those lawyers. So I think my guidance would be that you should have some sort of guidance on how to, are the employees allowed to use it in generating works? If they do, what should they be doing with it? Should it be checked in another way or in another fashion? Should it be disclosed or not to the client? Because maybe you did some artwork. Maybe the client now has this in their commercial. Maybe the client now gets sued from the person who is liable for that. So, these are some things you may want to keep in mind.
Great question, great answer. Any other questions? Steve?
Yeah, about watermarking. I know I can put my logo onto a photo, but do you have specific ways of putting tracking on there some way that is copyrightable or is easier to track than a watermark? Because I know there's AI tools that could just remove a watermark anyway.
Yeah, I did see something semi-recently where somebody had some sort of tool, and I don't remember the specifics, but they basically had a tool where in the pixels of the image, they set up something very specifically within the bits of the pixels, such that the AI training kind of ignored it, or when this thing was used later on as training data, you were able to detect those flips in those bits in whatever way it was. But I don't remember enough detail to be able to tell you who, what, where.
Okay. And I know if I put something,
so it's like effectively like a digital watermark.
Yeah. So if I put something in the metadata, it wouldn't matter anyway, because it would be, if a screenshot's taken, that's not even captured.
Yeah, so no, this wasn't metadata related. This was literally in the pixels of the image. Yeah. Cool. So basically, I don't remember if it was like, so a lot of these models that are used to train AI, they tend to look in how they extract features, they'll tend to look a lot at edges. So maybe if I had like a highlighter here in my image, it's going to see the edges of this. And so if I remember right, maybe it did something around those edges or something. I honestly, I don't remember enough detail though. But you're right. With regular watermarks, you could just pop them right off. But that's also an extra step that they have to take. They have to affirmatively do this. And a lot of times the way a lot like DALL-E 2, which is OpenAI, the way it was training primarily was crawling the internet, finding words on the same web page, using that as the tags for whatever your image was. So they weren't doing any additional processing to the image in terms of, stripping off watermarks or transforming it in some way or rotating or stretching or anything else. They were literally just, hey, there's a picture of John and there's info in John's bio around him. Let's grab all that as tags.
Interesting. It's developing
She
area.
added a link to a tool. I'm not sure, I'm not looking at it, but the title says, this tool uses poison to help artists protect their work from AI scraping. I'm looking forward to following that link. So, any other
So
questions?
yeah, it's
Okay. I want to first and foremost thank John and George. Fantastic information. For those of you who are participating today, I will be reaching out to each of you to hear some feedback, primarily because, you know, the next few months, I want to put together some additional helpful webinars, seminars, and, you know, so expect an outreach from me. And lastly, there will be a recording, a copy of the recording, a link to the recording, so that everyone who's here, everyone who registered who couldn't make it, will get a copy of an opportunity to review what's here. And I thank you for your time in very busy lives. I'm glad that you could join us, and I hope we provided some really good content and information for you. And
Really,
by the way,
really
one last
interesting
plug for
conversation.
Carter DeLuca. One last plug. If you noticed after my name, there's a pending trademark on Marketing Medic. Mr. Likourezos is my trademark attorney, just, you know, personal referral. And I would not trust any other trademark attorney or IP firm. I had my choice of about a dozen. So thank you all for attending, and have a great afternoon. And as I said, keep your eyes on the email. I'm going to do an outreach in a little while just to get some feedback. All right.
Thank you,
Thank
everyone.
you.
Be
Bye-bye.
well all.
Bye.
Looks like, okay. Hey, Steve. We have to reconnect.
Turn off. Yeah, we do have to reconnect. Yeah. So at some